This is the second part of the lecture on criminal law and emotion. In the first part of this lecture, emotions were tackled from the vantage point of non-legal phenomena influencing legal decision-making. In that role, emotions were recognized as both an indispensable element in the process as well as potentially detrimental factor obscuring and unduly biasing rational process of legal reasoning. Therefore, it is easy to overlook that, on the other hand, emotions in criminal law often play a prominent legal role of the very normative elements in legal rules. Performing in this role, they pose a duty, and often challenge, to jurists to furnish them with legal definitions to recognize, interpret, and prove them. As a starting point, let us take, for example, the following provision on excessive self-defense from the Slovenian Criminal Code. The provision reads, "In the event the perpetrator has acted beyond the limits of justifiable self-defense, he or she may receive a more lenient sentence. When he or she acts due to severe irritation or great fear caused by attack, he or her punishment may be remitted." When the court is applying this provision and is considering whether the defendant exceeding self-defense acted due to the severe irritation or great fear caused by the attack, it will first need to interpret the terms severe irritation and great fear. The defense that has been shifted the burden of proof in this case needs to establish that the perpetrator was indeed in an emotional state that matches one of these definitions. Despite these being legal terms, they derive their meaning from and need to correspond to actual experienced emotions. Hence, in establishing these facts, the court needs to find the way to unravel, ex post facto, deeply subjective experiences of effects in the perpetrator. This may pose difficult evidentiary challenges, which in practice usually require assistance of an expert, a psychiatrist or a psychologist. The present example pertains to the rules on sentencing. However, emotions are waived into legal norms of many other eminent criminal law subject matters of both substantive and procedural nature. One such important area are rules of culpability and excuses, more specifically on criminal insanity and diminished capacity. While typically the application of these rules require underlying mental condition or sometimes intoxication with psychoactive substances, many legislations also allow for the application of the rules on diminished capacity and insanity, even due to the extreme emotional excitation. This might be the case with offenders acting under uncontrollable rage, severe anxiety, shock, or in a panic attack. Moreover, emotions may stand as distinctive normative elements of particular modes of criminal offenses. Thus, for example, in some jurisdictions, the perpetrator's excusable state of extreme emotion or psychological stress is the normative element constituting a mitigated form of homicide. Even more often, however, emotions appear in criminal offenses as their implicit presumptions. Hate crimes present one such example. What typically qualifies these acts as hate crimes, as opposed to the other forms of violent or other offenses, is that they are motivated by the emotions of hatred, or perhaps moral disgust, contempt, or similar effect, rooted in prejudice or bias against certain social group. Furthermore, many jurisdictions have recently criminalized offenses generally termed as revenge pornography. Although definitions vary, this type of offenses may be distinguished from similar unlawful sharing of another's intimate content in that they are incited out of revenge. Finally, some criminal offenses can only be committed in the perpetrator's conduct cause, as a certain emotion in the victim, or if such a conduct is typically capable of causing a certain feeling. In many jurisdictions, this is the case with rather common crimes, including threat, extortion, or stalking, which might require that the perpetrator's conduct is capable of instilling fright or other emotional distress in the victim. Another area where emotions play an important and often controversial normative role in criminal law are sentencing decisions. Legal orders vary in how they prescribe emotions of defendants and victims to be taken into account and deciding upon an appropriate sentence. Some legal orders explicitly lay down particular emotions that decision makers need to consider, for example, remorse. Some legal orders only exemplify typical emotions that can be considered in sentencing, whereas other jurisdictions leave a wider discretion relating to the factors the courts may or may not take into account. In practice, emotions in the perpetrator are often considered as aggravating or mitigating factors when they are weighed as motives for an offense. Vengeance, jealousy, envy, and hatred are examples of such aggravation factors. On the other hand, a judge or jury may consider motives in offenses committed out of compassion, pity, love, or provoked rage as mitigating factors. An even more controversial matter in sentencing are emotions displayed by the offender after committing a crime, such as shame, regret, or guilt. In this context, remorse has gained the most theoretical attention. The displayed remorse by the defendant is normally considered a mitigating factor leading to a more lenient sentence. Interestingly, however, the court sometimes even expects the defendant to show this particular emotion during a trial. Hence, the lack of displayed remorse, or remorse that is feigned, can be used as an aggravating factor when a court imposes a criminal sanction. Victims' emotions, distress caused by the committed offense, can be a similarly deciding factor in sentencing. Considering victims' suffering as a relevant circumstance is applying sentence has not been disputed. However, more controversy has been stirred by the victim impact statements allowed in many common law jurisdictions. With a victim impact statement, the victim obtains an opportunity to present to the court how the offense has affected her life, but sometimes also to propose a sentencing recommendation to the court. Such statements, particularly in the capital punishment trials in the United States, have become increasingly emotional. Sometimes they include video material underlaid with evocative music, resembling a documentary film about the victim's life. This led to the dilemma, dealt even by the Supreme Court of the United States, where the particular victim impact statements were overly emotional. Many feared that emotionally charged content might unduly bias the jury or judge and thus render sentencing decisions unfair. Focusing on solely procedural criminal law norms, we find that emotions sometimes take a central stage in that area as well. In this context, especially emotions of victims and other witnesses are of concern. On the one hand, procedural regulations should strive to prevent additional emotional harm or secondary victimization that the criminal trial might cause to these vulnerable participants. On the other hand, however, such protective measures should not overly impose on the defendant's fair trial rights. Pursuing the first goal, many contemporary criminal procedures include sets of regulations aiming at preventing intimidation, humiliation, and fear in victims and other witnesses. In fact, in the European Union, a special directive imposed an obligation on all member states to adopt procedural measures in their domestic laws that would recognize and prevent potential emotional distress in victims during pretrial and trial proceedings. On the other hand, however, the jurisprudence of the European Court of Human Rights cautions that the concern for the emotional well being of witnesses should not breach the defendant's conventional fair trial rights, namely, the right to examine witnesses against him. Moreover, effects as more distant procedural factors should be also considered in other procedural undertaking of various criminal trial participants. Let us take, for example, false admission of guilt made by the defendant under threat, or a witness's perjury motivated by revenge. Such acts, which are procedurally invalid, are directly motivated by emotions. Perhaps more indirectly, but not less importantly, emotions act in the background of the traditional instruments of procedural law, oaths. Historically, the effectiveness of an oath stem from the fear of deity's wrath and punishment in case the person taking the oath breaches it. Notwithstanding its archaic roots, the oath of affirmation, taken by various procedural actors, remains an inevitable component in almost any contemporary criminal procedure. It seems that an important factor for its effectiveness still nowadays lies in the psychological, particularly emotional weight that the act of swearing imposes. The person taking the oath is not only motivated by the fear of a pending legal sanction if she breaks it, and the expected emotions of guilt or shame, but also by moral pride in keeping to the oath. Furthermore, all criminal proceedings usually give authority to the presiding judge to prevent a sanction, undue acts of insult, humiliation, or other emotional harm to any participants of the proceedings in order to protect the dignity of the persons involved and the authority of the court itself. Finally, attention should also be brought to restorative justice mechanisms that increasingly complement regular criminal proceedings in contemporary jurisdictions. While the advantages of these alternatives to traditional criminal proceedings are manifold, their emotional aspects should not be underestimated. A crucial advantage of successful restorative justice programs is the alleviation of negative emotions, not only those of the victim and the offender, but also of other stakeholders, sometimes even the wider community affected by the offense. This emotional discharging prevents new criminogenic situations among those involved in the incident and in their immediate social environment. Decision makers in the police, prosecuting authorities, and courts selecting suitable cases to be diverted to restorative justice mechanisms are therefore often instructed by procedural norms or guidelines to consider these emotional aspects of cases as criteria. Lastly, we should also touch upon the acts of clemency. In various jurisdictions, pardons may be granted by different authorities, often by the head of state, government, or some other body. In effect, clemency absolves a convicted person, or defendant before conviction, of all or some consequences of the criminal conviction. Reasons for a granted pardon vary. Nevertheless, this institution is often understood as a correction of a particular criminal justice system outcome. While it would be naive to claim that nowadays clemency is based on actual emotions felt by those in charge of the decision, the etymology of the term clearly reveals its emotional background, at least in its symbolic dimensions. Thus, an act of clemency often reflects a public, rather than initially sovereign, sentiment about a particular criminal case or a particular convicted person. The public might feel sympathy, compassion, or pity towards the convicted person that the public believes did not deserve a conviction, or the society. Such public sentiments may legitimize discretionary clemency decisions and thus reduce concerns over arbitrariness. The provided examples are not exhaustive in any way, but nevertheless support the assertion that emotion is indeed part of a parcel of a very normative structure of both substantive and procedural criminal law. Criminal trials and related criminal proceedings are highly formalized and uniform processes if viewed through normative lenses. However, criminal law proceedings can be observed also as social phenomena, as dynamic interactions among the involved stakeholders embedded in a specific cultural environments and institutional settings. Moreover, the participants, judges, attorneys, defendants, witnesses, are often different social status and hold various amounts of social power. Social legal research that explores these aspects of court proceedings has been increasingly paying attention to the function of emotions therein. This strand of research observes how emotions are displayed, managed, interpreted, or instrumentally employed by various procedural actors for various purposes. Social legal analysis of emotion in judicial context builds upon concepts developed in sociology of emotion and applies them to legal setting. One such important concept is emotional labor. It denotes adapting, that is, suppressing or inducing, emotions to fit a particular social or professional setting according to the so called feeling rules. Feeling rules in judicial context are expectations which emotions and how or or not to be displayed in a particular court situation, for example, during witness interrogation. Judges and other legal practitioners may use emotion management in court to regulate their own emotions and emotions of the trial participants. Hence, properly applied emotion management can be a highly beneficial and powerful tool in criminal proceedings. It can be used to strengthen decision making in criminal law through various strategies. For example, a judge who uses warm, calm, and compassionate communication mode in addressing a frightened or nervous witness may acquire from the witness more and more accurate information, which will foster the truth finding process in the trial. Conversely, using cold and authoritative tone to remind a defense attorney that he is abusing his procedural rights might be an effective way for a judge to keep an adversarial balance between the parties and to ensure orderly progress of a procedure. On the other hand, a judicial decision maker may also employ emotional management to regulate her own emotions. By doing so, a judge may again pursue different objectives. Perhaps she might want to exhibit dispassion during an emotionally heavily charged testimony to convey the appearance of neutrality, impartiality, and procedural fairness to the public. However, a judge might also want to regulate her experienced, not just displayed, emotion in order to avoid unwanted bias in her decision making. In an insightful study of Australian judicial officers, Roach and Le and Mark reveal different methods and techniques that judges use to regulate their own effects. These include self talk, an internal discourse with oneself as a conscious self reminder of one's formal function, adjournment of proceedings, often restored when a judge feels anger, is an efficient and immediate way for a judge to distance herself from the emotion triggering situation, to reflect upon it and her feelings, and to regain composure. Furthermore, judges make use of debriefings with colleagues and peers as a method to unburden emotion related stress, whereas sometimes they also take advantage of humor for this purpose. Notwithstanding our focus on judges' emotion management, it should be pointed out that this practice is equally available and used by other criminal justice participants. However, the flip side of the emotional management is the danger of its instrumental use that can be equally powerful weapon working against procedural fairness and legitimacy of criminal justice. Thus, criminal justice participants may take advantage of emotions to manipulate other stakeholders, to exert their social power, or to reaffirm their social status in the courtroom in manners that lack legitimacy. The many recent endeavors of scholars to tackle the role of emotions in criminal law have opened fascinating new perspectives on the decision making in the criminal law. Most importantly, they have allowed us to better understand the complexities and multidimensionality of this process. Despite still many unresolved challenges, these new insights should not be neglected. This is in the interest of the legal theory and legal practitioners who deal with emotions and legal decisions on a daily basis. But ultimately, it is in the interest of all the criminal justice participants. Embracing a thoroughly multidisciplinary research on emotion in criminal justice does in no way threaten the central criminal law postulates as we have nurtured and developed through centuries. On the contrary, by better understanding the element of emotion that had previously been either intentionally ignored or unintentionally overlooked by the criminal law doctrine, we may take a better use of the fundamental criminal law principles and develop them further with the aspiration of a just application of the criminal law.